number D500910, Jensen versus Jensen. Counsel, please state your names and bar numbers for the record.
Thank you, Your Honor. Patricia Vaccarino, bar number 5157. I'm present appearing with the plaintiff, Caroline Jensen.
Joseph Carey, Attorney 10634, and Sabrina Dolson,
1305.
on behalf of the defendant Shane Jensen, who is present.
Do y'all know how much we love inheriting cases? Not. All right, but I did inherit this case. And I took a long look at everything that preceded me. I think I'm judge number 3, right?
Could be.
Yeah. And I've read through the hearings. I've read through the various motions, especially the post-decree motions. And I have a lot of good news, bad news stuff going on here. Okay? And I think the way I'm going to view the motions that started all this will kind of maybe moot out the subsequent motions. Okay? And I have lots of notes.
Sir, would you like us to hear you out before you accept, or you're not going to accept oral argument today? Because whatever the court please.
Let me talk first.
Thank you, Your Honor.
Okay?
Do
My
you mind
court.
if we take a seat?
Yes. I
No,
said
you don't
protocol.
mind if we take a seat? Oh.
You can sit. I said protocol.
Thank you, Your Honor.
All right. The last order regarding child support was on July 8th, 2015, and that was by way of a stipulation and order. If there has not been a material change in circumstances as it pertains to income of the parties, then any motion to modify child support must be filed after July 8th of 2018, so that there's a relook. This is where we get to the good news, bad news. Bad news for the plaintiff is this motion to modify child support is premature. Good news for the plaintiff is it's now past July 8th of 2018. As to the issue of whether or not there's been a change, because we have to look at this not only under Rivero but also under Bluestein. If I look at that, I don't know, as I sit here today, whether the timeshare as such under Rivero meets that Rivero designation. And I appreciate that Rivero is under review right now. I don't know when we're going to get a decision on that, but it's currently under review. But it is still the law of the land. Bluestein tells me that you look at what the parties intended as a timeshare, irrespective of the labels, which is why I get back to the issue of what the actual timeshare is. When I go look at Rivero, I have to look at a year, days of a year, out of a year. So out of 365 or 366, depending on if it's a leap year, I have to look at those days, okay? And I don't know the answer to the question. That becomes an evidentiary issue. So here's what I'd like to do. I'll take argument if you need to, but you're likely not to change my mind. We could do option number 1, which is I deny the motion to modify child support pending an evidentiary hearing on the issue of timeshare. Or, Ms. Vaccarino, it is now November of 2018, which I believe is after July 8th of 2018. And you can confer with your client to see if you want to reposit your motion. That's your choice. Either have an evidentiary hearing, we spend a lot of money, or there's a mandatory 3-year review. That is the law. And that hasn't changed yet. And even in the new child support provisions, it's not going to change. there's still gonna be a 3-year review, okay? Then, we can handle it all at one time. Otherwise, we're handling it piecemeal by setting an evidentiary hearing on whether or not the parties still have joint physical custody pursuant to their stipulation. And I don't know the answer to the question, because it's not my job to start going through the calendar and counting days. I think the parties have to show me by way of an evidentiary presentation whether or not it meets that 40%. And I don't know. There's a lot of problems with Rivero, by the way. I'm not a fan of the decision, okay, because it raises all of these complexities, but if I couple Rivero with Bluestein tells me, frankly, that I have to look at days. Bluestein says the labels are not as relevant as the actual timeshare. And if, in fact, the parties intended a joint physical custody, then I have to figure out a timeshare that honors that. You know, all of these cases are in play. And I don't have the ability today to answer that mathematical question.
If I may, Your Honor, I believe you're, with all due respect, you are, there, you said it has to be a material change, quote unquote, in circumstance?
20%.
Okay, that's, with respect, Your Honor, under the statute, it's 20%. And we submit to you, even Judge Steele and the defendant concedes his income has raised 20%. That's number one. Number two, his income is raised since we were here last August, I believe, because we believe he's flying internationally, and under the law, it's not Finn's fault that the motion's been pending since October 24, 17. It reminds me of that Beatles song, The Long and Winding Road to Get Down the Path.
I know.
And you're right, Rivero told me, Bluestein tells me,
Counsel, stay close to the
thank you,
mic.
Fernandez tells me to, under public policy, you have to look, and even Miller, Your Honor, it's a 2018 case in the supplement. You today have to award Finn child support. Regardless of the timeshare, he owes the statutory cap. Judge Steele agreed with that. You know what? Opposing
Whose
counsel.
case is it now?
Your Honor, it's your case, but
She set aside everything, counsel.
I'm allowed
so
to
now
argue-
no.
I'm not allowed
Counsel,
to argue
it's my court, and I'll tell you when you can continue on.
Thank you.
Because I have been from day one annoyingly Socratic. Okay? Annoyingly so. I know that. So I do interrupt lawyers.
Okay.
Okay, because I want to make a point. The point I'm making is Judge Steele retracted everything. Okay? So I don't have an pending order that I have to look at gross error or not gross error. I have no order.
I understand.
So I have to look at it fresh from my perspective, and I just want you to understand that. So every time you say Judge Steele did this, Judge Steele did that, she retracted it all.
Your Honor, have you, to make your finding today, upon the motion, that there was not a 20% change in income on the obligor's behalf, what numbers did you use? Because the last time he filed an FDF...
Are you cross-examining me, counsel?
Your Honor, I'm asking findings for the record because
No,
I may need to file a writ.
it's your job, counsel,
I'm
to
telling you,
demonstrate
he's
to
been-
me that he has had a 20% increase since July of 2015.
He has, Your Honor. And we've
You haven't
written
shown
that in the if you want me to go back to my motion and give me a 3-minute recess to do that, I will show you, and I will also show you his income. You can swear him in today,
Counsel, you could make life simple
but what
for
you're
your
telling
client.
my client is she has to spend twice the amount of the child support to which her son is
Your
entitled.
Honor, I'll cut this.
No interruption.
All I'm saying is this, if I only went to the child support division tomorrow and said I don't want to contest custody, I would get a child support order in 90 to 120 days. Because they're just going to look at it and say, what's your income, what's yours? And I don't know that you think that 3-year rule is so bright. But you've also said, Your Honor, because you're here not on behalf of her or her, you're here as the advocate for the child necessitating child support. And if we know that the 3-year review has run, why is it not today, November 7th, the right day, to ask these, to make sure we're right, that you're right about we haven't met the 20%, and now guess what, we're in a quandary because we have to refile maybe because we're in between this 1 year. So I may, and the reason I'm not trying to upset this court, what I'm trying to do is make a record
I'm
because
not upset.
I may have to, thank you, and I'm not either, because sometimes people seem that, I'm just trying to make the record based upon the law we have.
But do it
and the
briefly,
facts.
counsel.
Your Honor, it's been a year,
Mhm.
and my client right now, well, Finn, has only received $8,100 in the last 41 months. That's 3 years and 6 months. Is that satisfactory to this court? Or does this court feel that he is paying the right amount in his child support
Let
obligation?
me
And that's what I think
explain
that
to you.
where you need to understand. This isn't about either party or either
Counsel.
counsel.
Let me explain one thing to you. I cannot, in ruling on a motion, it's like UCCJEA custody issues. I have to look at it as of the date of the motion. I can't just all of a sudden say, well, now that enough time has passed, so it's all good. I have to start with the date of the motion. I have a motion filed in October 2017. It was followed up by a second motion on the same issue filed in March of 2018. Had you waited until July of 2018, it would be an entirely different inquiry.
I think you're wrong, Your Honor. You're saying that
Well, but guess what? It's my
it's 3
court.
years since the last date, and this child still is being under-supported. And you're saying that the filing, the bright line rule of the filing is
Why are
going
you
to
putting words in my mouth?
control public
Okay,
policy?
sit down.
You are saying that.
Sit down.
I don't understand
Sit
why
down.
today this child is
When I say sit down, you sit down. Okay. The second thing, good news, bad news, is that your client is responsible for the tuition obligation under the decree of divorce because the stipulation didn't change that. And simply because for a period of time the child went to another school, not Maryhill, once he went back to Maryhill, that obligation kicked back in. So that, I would hold him responsible. I would. That aspect of the motion I would grant because that is an obligation.
Are you granting that today, Your Honor, under the contract in the case? Because that would help. That would help
Are we
the
looking
child.
at the whole, I mean,
Because you can grant certain issues off
When
one motion.
did
I'm
I
sorry.
allow my courtroom to
I
become a
apologize.
free-for-all?
I should not have.
Counsel, you both have been appearing in front of me for years, and you know I control my courtroom. I don't allow interruption. If I ask an attorney to stop talking, I expect them to stop talking, and I expect both attorneys to, as much as humanly possible, treat each other with some modicum of respect. Okay? Part of the problem with this case, it's the joy of inheriting a case, because every judge runs their courtroom differently. The fact is, I am a bit sympathetic to your client, Ms. Macarino, on this issue, and that is that this case has dragged out far, far too long. And when I don't get orders from lawyers, I handle it differently. I issue orders to show cause. I hold lawyers in contempt. I don't set aside everything. But that's how I run my court. I'm not here to tell Judge Steele how to run her court. The fact is, I inherited this problem. So what I'm trying to do is distill what issues there are. And what I'm looking at, and this is one of the things I hope you'll talk about, is we have two options. I call it door number one, door number two. No door number three. Door number one, which is the one that makes the most sense of all, to me, from my perspective, because I like simplicity, is for your client tomorrow to file a motion to modify child support and address what, if any, arrears there are. By the way, that's a mandatory attorney's fee award. And also to address what is the actual timeshare of the parties. We start fresh, okay? Because I think this has created a lot of chaos for these litigants, and undoubtedly some of it has been observed by their boy. You'd be surprised how smart kids are. They notice stuff. They know stuff is going on, even if the parents say nothing. Even if you're doing the best you can to protect your boy, he knows something's going on, okay? And he knows that mommy and daddy are not happy with each other right now. He might not know why, but he knows it. And that's hard on him. That's why I like to simplify things, because it's not my job to punish or reward parents. It's my job to try to protect kids. If we started fresh, yes, there is a cost associated with having to start fresh, but it's cleaner. It's truly cleaner than the record that I've inherited right now. Door number two is I order an evidentiary hearing, at which time the plaintiff will have the burden of proof to demonstrate A, that the defendant's income has increased by 20% since July 8th of 2015, and or that whether it has or not, that in fact the parties are not exercising a joint physical custodian timeshare, which is counting the days over, a year's time. Those are your two options. I personally, but I can't tell you what to do. I have not total control. I like that option because it really distills the issues and it creates much better opportunities to negotiate. You put the past aside, you negotiate. But that's your call. I would rather counsel you spoke to each other and decided which route you want to take.
Could I suggest?
I do think that door number 2 is a little messier.
Could I
Yes.
suggest something? Would it be possible, if they're in agreement, we would certainly have no objection to attending a senior judge settlement conference or a settlement conference.
We've tried to settle so
No.
many times.
I'm
It
not
would help
doing-
us to have a third-party
We
neutral
just-
present.
It just doesn't help. They were so, it's really all
Why are
fine.
you interrupting
I'm
Mr.
sorry.
Mr. Carasoni? There are certain times and certain types of cases that I think are fairly referred out, okay? And there are some senior judges that are better than others at understanding the issues, and you don't get to pick. Could it mediate with enough attention? Yes, but this isn't a 3-hour mediation. We have a program now where you could go, if I refer you to another of my colleagues, you do it, but you're still only getting 3 hours, and that's not enough. That is not enough because this case got so messy over time. I don't see it as, so as I look at my duty to sit and my obligation to the system, I have to try the case. So the issue is which case we try. And that's something I think is something that could be fairly discussed by the parties to see what they want to do. The problem is there has been so much that has gone on in this case that it's created, and I'm not necessarily putting the fault on one party or the other, or Judge Steele. It got messy. I like simplicity, I always have. I do think the likelihood is great, and this is your bad news, that if Ms. Vaccarino chooses door number 1, your client's going to pay a lot more in child support. Whether it's a joint or primary, that's a given.
You know what, honestly, Your Honor, that's not his concern. He just wants to have the time with his child. And
Well,
so
then
we're not,
those are discussions too.
I mean, that's not,
I don't know if
he's
your
not
client-
so much concerned
I don't know
about
if
the
your
child
client
support
has
and if
the
there's a change.
ability to come back and, make his domicile here, but at the same time, the plaintiff does not have as many options as one would think. I know somebody who actually does what she does, who's now in Washington, going to school. And he and his wife have no idea when the school's over in a year, where they're going to be living. And when you are in the military, and especially you're a pilot with the Air Force, you don't know if they're going to send you to England or somewhere else like that. You don't know the answer to that question. So I'm not suggesting your client necessarily follow her wherever she's going to go, because he can't do that.
No, but what's great, Your Honor, is that he has the ability with his job to exercise. He's one of the few
I
people
get it.
that you'll ever see who can live in another state and do joint physical custody
I know
because he's a
that.
pilot, and it's
I
great.
know that. I do
So-
know that. I also have had a case where one of the litigants took a job in California but can spend enough time in Nevada and have two residences where joint physical custody can take place. I'm not unmindful of that. There are lots of opportunities. And the reality for the plaintiff is, as she wants to advance in the Air Force, she may not have choices in the future. So the idea that they can start working together and problem solve together is really what they need.
Hence the reason I suggested maybe a settlement conference. But
I don't see a settlement conference here because I think we got math. We got math. Settlement conference judges don't do math. It's not their job. No, it's me. You're stuck with me, Mr. Carajani. Sorry.
oh no, I'm not.
No, that's okay. I don't. And Ms. Vaccarino might be saying,
No, honestly, Your Honor, I'm glad if I may speak, if you're taking a very thoughtful approach to how to approach this. And from a legal standpoint, what I need then to show you that we're right, either door one or door two is the same analysis, no matter when I file first or second.
actually, it's not.
I need his tax returns. I need his 14, 15, 16, 17,
And
and
what I'm
18.
saying is, here's
And I can do the math for you and show you we were right in 17.
Here's the deal.
That's what I'm trying to tell you, either option. I want it simple as possible, but you're right. He can go outside right now that he's heard your preliminary thoughts. I think we might be able to sell this if you give us 10 minutes, if they please. Because I am somewhat surprised by some of your preliminary rulings and thoughts. I believe some of these rulings can be made today without deferring till trial, because that only harms a child.
I don't.
The only thing I'm worried about is if I pick door number 2 or door number 1 and I file, I can't have you erase the $23,000
No, I can't.
it cost for mom to ask for a review.
I appreciate that.
So that's
but
why I'm
that was
saying I'd
not
still do door
something I
number
can
1.
prevent.
You can still look at the record, and under the law, you're allowed to award
Ms.
prevailing party
Vaccarino, would you
fees.
please talk to Mr. Carajani
I will.
and pick a door? And it may be that you can settle the whole shooting match, because Mr. Carajani's client can recognize that whatever I do, there will be a modification of child support.
I don't
understand
and
that
it may
I don't have to file another motion.
Ironically,
I go right to my motion.
ironically, with his income and your client's income, it could be the same number irrespective of primary.
Exactly,
be.
exactly. And he has started exercising his school year time. So to have a whole evidentiary hearing on timeshare a year later,
I don't-
he's changed his posture. So
I
I don't
don't
want to waste
want,
your time.
I don't want Finn's parents to have an evidentiary hearing, okay?
So that's why
That's
was my
for Finn.
suggestion was settlement conference for 10 minutes in the hallway and let Judge Steele very assertively then rule upon what motion request you believe you can. If I disagree, I can file a written say she should have given
Your
child
Honor,
support.
this is the reason this case. I don't know if you've watched the prior videos. It's just been like this constantly, and Judge Steele finally threw up her hands.
Oh,
So
good advocacy.
Okay.
I think
I
that
do not
this is
find
dragged
at this
off.
juncture in my courtroom, because Ms. Vaccarino's been in front of me enough to know that Ms. Vaccarino's behavior troubles me at all. Okay? I control my courtroom. She knows I control my courtroom. She has been properly respectful. I know she gets a little excited. But I don't want this to be about the lawyers.
I agree.
You're going to get to a certain issue however you reach it. A certain number, however you reach it. You can do it easy or you can do it hard. Your clients could walk out of this courtroom and frustratingly have nothing to fight about. And I think for Finn's sake, that's a real good idea.
We agree, completely.
And your client's dealing with an inevitability. Mr. Accarino, I understand, is very concerned about the amount of litigation that has taken place up to this point, something I can't do anything about.
You can at the attorney fee phase, once you get to the meat of it.
But
Or
No,
if we
I
settle it.
can't. No, I can't, and I won't. So go
You're-
pick door number 1 or door number 2. If you pick door number 2, maybe you can make your argument about attorney's fees, but that assumes you're prevailing party.
Right, and,
But so go talk.
okay, we can talk about settlement, because I know already which door is in the
Tell
child
me
assistance.
which door you're going to pick, but I think it's gotta be a decision that you make together, recognizing. Make a decision.
I'll
Have
try
your
one more
clients
time,
agree on something.
try one more time,
Please do.
we have, my client's been to mediation twice,
And
to try and
I
get
don't
it.
know why she keeps bringing that up. I mean, certainly it's not my client's fault the case hasn't resolved.
That's where we just.
Hey, you know what? Would you teach your clients something? How to treat each other with respect.
They actually shared in a birthday celebration for their
No,
son.
no, I'm
early.
talking to the lawyers.
Thank you.